Good evening, everyone. We are extremely sorry for the delay caused to you. A very warm welcome to this live masterclass organized by Lee Spiritus. Today's session on do and don'ts of arguing regular bail application in trial courts is being led by Advocate Hrushikesh Wani, a proud alumnus of ILS Law College Pune and Nalsar Hyderabad. Mr. Wani brings with him over 5 years of rich experience in criminal and civil litigation. Sir primarily practices at the District Courts of Maharashtra, High Court of Bombay with a strong focus on criminal trials. So without further delay, let's begin this enriching session. Over to you, sir.
Hello everyone. Good evening. So, a very thank, uh, I'm very thankful to Liz Peters for providing this opportunity to be in front of you all, and we'll be discussing today do's and don'ts of arguing a bail application before a trial court. So, sir has introduced me, and without further delay, I'll start with what, sir, if he has shared the presentation. So, first of all, what do we do when we, so am I audible to everyone?
Yes, sir, you are audible.
Yes. So first of all, in general sense, the Indian courts and judges have forgotten the principle laid down by the Supreme Court that bail is a rule and jail is an exception. And focusing on that only, we are going to have this session of today's. The key things that we will be going through in this today's session are the statutory frameworks that are laid down about bail in Bhartiya Nagarik Suraksha Sanhita 2023, as well as what are the do's that you should be doing while arguing a bail application, and what you should not be doing while arguing a bail application. Because the most important part of a trial or a bail application is what an advocate should not do. Everyone knows what should be done, but what shouldn't be done is very important, because in trial, such basic things cost you and your client. And so the other focus will be on where what else we will be covering is specifications relating to arguing bail applications relating to offenses against women and POCSO cases. Also, I'll be covering a few landmark cases that have been laid down by the Honorable Supreme Court regarding bail. So, starting with the first part of this bail. Sorry, if you can select the second slide. Satyendra sir, if you can go to the second slide.
Yes, sir. Just a second, sir. Just a second. I'm saying.
So till Satyendra sir comes to the second slide, I'll just give you an overview of what is this concept of bail. So many of you must be aware. I see many of you are advocates here, and few of you must be new law students who are stepping into this profession. So bail is granted. Bail is a concept that has been developed so that the liberty given by the Constitution to a person is not taken away unnecessarily. So what happens when a case is registered against any accused? The trial takes time. The investigation takes time, then the charge sheet is filed. And in the meanwhile, because there is pendency of cases also, so considering all these aspects, the trial takes time, and someone's accused or any person's liberty must not be curtailed unnecessarily. So this concept of bail has originated. So till the trial of any offense is concluded, we have a presumption of innocence. That means till someone is proven guilty, he is considered to be innocent. And in such case, if he is considered to be innocent, it won't be fruitful to keep him behind bars and to curtail his liberty. And that's why this concept of bail has originated. So what is bail? Bail is, meaning of bail is, an accused is released on some kind of surety, or someone else takes his surety that he won't run away from the justice system, and that if he is let out of the prison for time being till the trial is concluded, he will abide to the justice and he won't run away or he won't flee away. And for that purpose, bail, this concept of bail has been introduced, or it is a part of our criminal law system in India. So there are under Bhartiya Nagarik Suraksha Sanhita, there are, so if an accused, there are that I sir, अगर आप next slide पे जा सकते हो तो next provisions related to PA. So what all provisions relating to bail are enshrined in this Bhartiya Nagarik Suraksha Sanhita? So first is section 478. It is bail in non-bailable offences. So this Bhartiya Nagarik Suraksha Sanhita, previously CRPC, or then the Bhartiya Nyaya Sanhita. So in these all of these codes or these acts, the few offences are categorized as bailable offences, few offences are categorized as non-bailable offences. So this provision of section 478, I like to you guys to note all these provisions. I like you to note them down so you can just read them after this webinar is concluded, and it will be fruitful to you. So this first section, it relates to bail in bailable offences. So in bailable offences, by default, an accused is to be released on bail. But while releasing him on bail, he has to furnish some kind of surety, and that procedure is laid down in section 478 of Bhartiya Nagarik Suraksha Sanhita. After that, there is section 480. Both these sections, section 478 and 480, are applicable to offences or trials that go before a magistrate. So section 480 is bail in non-bailable offences which are triable by a magistrate. So then comes section 482, which is a very, now we have, it is widely used, and if you guys have any questions, then you can ask at the end of this webinar, because this chat box keeps popping up and it is a bit of distraction. So section 482 is relating to anticipatory bail. So the powers of anticipatory bail are granted to a sessions court as well as a high court. But whenever an offense is registered against anyone, it is practice that you should approach a sessions court first, because if you will directly approach a high court, the high court will ask you to go and exhaust your remedy before a trial court, and then only they'll entertain your application if you have already exhausted the remedy of 482 before a sessions court. And now coming to section 483. Section 483 of Bhartiya Nagarik Suraksha Sanhita gives special powers to the sessions court as well as the high court relating to bail. So this is a section which is applicable to regular bail. So now I'll first tell you categories of bail application. There is one category of bail applications that is regular bail application, and there is another category of bail applications that is anticipatory bail applications. So what are regular bail applications? Regular bail application is filed when an accused is taken into custody during investigation by police, and then remand of that accused takes place. Firstly, the police and investigation machineries, they ask for police custody remand of the accused. Why is police custody remand sought by the investigating machineries? It is sought for the purpose of the investigation to get information from the accused, to interrogate the accused, and then after they first within 24 hours, it is mandatory that if when a person is arrested by any police officer relating to any offense, he should be produced before the nearest magistrate. And after producing him before the nearest magistrate, the police then seek for his police custody. Then if you are representing an accused in such case where in a remand case, then you will have on the first day when he is produced before the magistrate for police custody, there is a remand report wherein they cite the reasons why they need police custody. And in such a case, if you are an advocate who is representing the accused in a remand, and then you have to tell the court that why police custody if your client, your accused, is not required, that the investigation is done, if any recovery is there from the accused, that is done, and there is no need of further interrogation or further investigation, and thus the accused should be taken into judicial custody. But most of the while, when we are dealing with offenses of serious nature, like a murder offense or a POCSO case or a offense of any offense which is against women or children, in such cases, mostly trial courts tend to give police custody of minimum 3 or 5 days of the accused for the purpose of further investigation. And then subsequently, the accused is again produced on the next date wherever his police custody ends. And again, the police or the prosecution will ask for his police custody, or if they have concluded the investigation, they'll ask for his magistrate custody. So while a regular bail application is filed, whether under section 480 or under section 483, you have to keep in mind that until and unless an accused is remanded to judicial custody, you cannot file a bail application. This is very important thing. And many of the junior advocates should, we are not, most of the seniors won't teach you this, but always keep in mind that whenever you have to file a bail application, it is very important only after the police custody of accused has ended and the magistrate sentences him to remands him to judicial custody, then and then only you can file a regular bail application. So while filing a regular bail application, there are a few points that you should consider, be it an anticipatory bail application or be it a regular bail application. I've made us, Satyendra sir, if you can go to slide number Zeba Khan. I have at the last. Zeba Khan. और नीचे. हाँ, this up the इसके पहले वाला. हाँ. So now we'll come to how a bail application should be drafted. Recently, few days ago, the Honorable Supreme Court has issued guidelines under this case of Zeba Khan versus State of Uttar Pradesh, wherein while drafting a bail applications, this I've you guys can note it down from the slide. You should also note the case name of the case, so you guys can read it afterwards. What has happened in this Zeba Khan case is the Honorable Supreme Court has given some guidelines while drafting a bail application. The criminal antecedents, if any are pending against the accused, should be written down in that application. If you have filed any other previously, if you have filed any bail application, any anticipatory bail application of the accused, or if this is the first bail application before charge sheet, if you have filed any bail application, you should write it in the bail application. Then you have to write the sections that are invoked against your accused. Then you have to write the number of the FIR. Then you have to, while drafting a bail application, you have to write the name of the police station where the crime is registered and the district as well as state. Also, it is very important that you write the total period of custody since the arrest of the accused, and also how many days of police custody he has undergone, and how many days of judicial custody he has undergone while filing a bail application. And then you have to write right there that what is the maximum punishment that is prescribed for what the sections that are invoked against your accused. And this should be supported by an affidavit of the accused or any close relative of accused. So this is not, the judgment doesn't talk about this, whether the affidavit should be filed by the accused or any of his relatives. But in practical procedures that is going on in the trial courts, now the courts allow filing an affidavit on behalf of the relative, close relative, whoever in case of anticipatory bail applications, what happens is the accused is absconding arrest and he is not in contact. So in that case, you can file an affidavit of his relative. Or also in regular bail applications also, you can file an affidavit of the relative. So these are few facts. Now, while drafting a bail application, you should state the name of the accused. Then you should state the formats. Most of you must be aware about the formats of applications that we draft. But his age should be written properly, where his stage should be written, and what occupation he does. It should also be written in the bail application. Then you should, and it is as an practice, you should keep always this in mind while drafting a regular bail application or an anticipatory bail application. Always put this story of the prosecution, in short, the facts of the matter, you should always keep them as a part of your application. Firstly, you state the type of application, whether it is a regular bail application or anticipatory bail application. Write the section. If it is a regular bail application, section 480 of Bhartiya Nagarik Suraksha Sanhita, regular bail application under section 480 of Bhartiya Nagarik Suraksha Sanhita, or regular bail application under 483 of Bhartiya Nagarik Suraksha Sanhita. Whether it is first bail application, second bail application, you should mention it in the bail applications draft. Then mention the story of the prosecution. So how to mention the story of the prosecution? Whatever are the contents of the FIR. So try and put those contents of the FIR in short in your bail application. So the judge, he can read those contents. Even if he does not read the FIR, he'll at least read those contents, and then he'll get a brief idea of about what your case, what allegations are there against your client or accused. And then you mention the grounds of the bail application. In the grounds part, you should mention whether this accused is what type of job he does, whether there is dependency on this accused, that whether he will not tamper evidence, he will abide by the conditions, and if he is released on bails by putting some conditions on him, then he'll abide by those. And then whatever your defense is while arguing a bail application, it is very important that you form a defense of your own. For that, for either the defense can be that you haven't committed this offense. In cases of if it is a consensual matter of POCSO, there are many cases of POCSO nowadays. In rural areas, we are seeing that there are many cases of POCSO involving children of the age of 18, males of age 18 and 17, whereas females of the same age, and then the families are opposing that relationship, and then POCSO case is registered. So if you want to give it a consensual aspect, that you have to prima facie show the court that this is a consensual case of consensual case, and then it has been converted into a POCSO case, then you should write it down in your bail application. Because if you don't state it in your grounds, then some judges might not let you argue it. Today only, before the court, advocate was trying to show some chats between the victim and the accused to the court, and the court specifically then asked him whether that WhatsApp chats have been mentioned, that there were WhatsApp chats between the accused and the victim was mentioned in the bail application or not. And then the advocate pointed out that he had mentioned. So these are the things that you should keep in mind, defense is very important while arguing a bail application. You should. So what is happening nowadays is that the guidelines of the Supreme Court that bail is rule and jail is an exception are not being followed before trial courts. And most of you who are practicing before trial courts may be knowing this, because the courts are now going into the gravity of offense. So gravity of offense should be looked into, but in heinous cases. While granting bail or while deciding a bail application, the judges of trial courts, in matters where the gravity of offense is not that serious, they are still going into gravity of offense. And then what is happening is judges and prosecution are kind of conducting mini trials at the stage of bail. And they will go into the gravity of offense, that offense is serious in nature, and the accused has committed a grave offense. All of these arguments come forth by the public prosecutors. And then what we have to do as advocates is we have to tackle their arguments. And this becomes a little bit difficult when we are trying to put up the case for bail. So prima facie defense that my accused has not committed this crime, or in cases, as I was told earlier, that consensual relationships, you can take that defense. And defenses should be taken by a criminal lawyer according to his case. So there are various types of cases and various types of defenses that we have to come forward for each case, depending on the facts of that case, that we have to, that is something you have to keep in mind while arguing a bail application. Now, coming further, sir, agar आप ये slide fourth slide पे आ सकते हो sir, fourth. उसके नीचे. Now, how you should start with your bail application? First, while opening a bail, I have already stated, जैसे मैंने बोला कि in the draft how you should go. The same, similarly, while starting your arguments, start by asking the court, firstly, humbly, be humble while you are practicing before trial courts. First and foremost rule is be humble, be grateful. Don't try to be aggressive before a trial court or any other court for that matter. Try to be humble before the court. We know everything. We know a lot. We have studied law. We come from moot backgrounds. We have the experience of moot courts. But moot courts and real courts, there is a huge gap. The judge sitting before you in a trial court has a lot of things going around in his mind. He has a lot of work to do throughout his day. And then when bail applications come for hearing, most of the judges are very reluctant to listen to you. And in trial courts, it is a little bit difficult. You have to know what that judge wants. You have to try and get an idea of how that judge is, what is his thinking, or what would he like to hear and he would not like to hear. All of this is a part and parcel of practice that will develop gradually over the years. But for the time being, for being a new advocate, first thing is be humble, be polite. Try not to be aggressive, not to be rude. Then when you stand up and when you ask the court, if you are called out, it's fine. Or in cases, many trial courts, you have to just let the court know that, yes, this is my matter, and should I start with the arguments, or it is for arguments, and then you start. So it is not like high courts in trial. Most of the trial courts, it does not work like high courts, that matters are not called serially. So be humble while starting to argue. Start by saying, may I please, sir or madam, whoever is presiding officer. And if many of you must be practicing before high court, so try and avoid addressing the judge as the lord, my lordship, or your ladyship. Try and keep it as your honor only, because trial court judges are not addressed as lordships or ladyships. So avoid that mistake. I've seen many advocates from the high court come to the lower trial courts and then they address the judge as your lordship, ladyship. So try and avoid. First and foremost, keep in mind mind that while addressing a trial court, it is your honor. May it please your honor. Start by this, then state that I have filed this application for regular bail or anticipatory bail, and then state the section under which you have filed the application. Now, as per Zeba Khan's guidelines, state all those facts that criminal antecedents are there or not, if what is the sections that are involved, what is the maximum punishment that is prescribed, then state how the period of custody that has been undergone by the accused, and then politely ask the judge if you should state the facts to the court. So if the judge has already read your file, then you can avoid, he'll tell you that you can state those them in brief. So while stating facts, this is very important. While you state the facts of or the allegations that are leveled against you, try and tell only those facts that you find are supporting your case. Allegations of serious nature, try not to give that much load or that much stress on them. So you just, if there are allegations that go against you, try to sum them up in a faster manner so the judge does not focus on them. Try to put the case in a way that it balances you and favors your accused. So while stating those facts and allegations against you, try to do this. Then you should start by your contentions. While you argue, then after the facts, you state the facts, try and then go with the contentions that you're going to argue. So first of all, while arguing a bail application, while you move on, try focus on your defense. Whatever defense you have thought in your mind while arguing a bail application, focus on that aspect. So prima facie, show the court that how your defense is like. If you are focusing on the aspect that your accused has not committed this crime, then point out the FIR, point out the contradictions in the FIR, point out if there is any lacuna left by the police, if there is delay in the FIR, point it out to the court that why this delay, if there is delay, and how it is fatal to the case of prosecution. Try and create a doubt in the mind of the court, prima facie, that this, we are talking about if your defense is that your accused has not committed this crime. Prima facie defense. I am not talking about trial here. I'm just talking about the bail aspect. And in bail aspect also, we have to nowadays create a defense because the courts are not considering bail as a right and jail as an exception. And that's why I'm telling you guys that while you argue your bail application, draw a defense, your own defense in your own mind, and then try to convince the court that this, if this is a false case that has been registered against your accused, if there are any pending personal grudges between the accused and the family of the victims or the complainant, so you can go talk about them also. So all of these aspects. And then when you come to the latter part, when you create a doubt in the mind of the court that this case is a false case that has been lodged against your mind, so you have to keep a balance between what, why bail there are, so why your accused must be granted bail. There are few cases of the Honorable Supreme Court. Sir, अगर आप वो नीचे लैंडमार्क जजमेंट्स पे जाओगे, ऊपर इससे ऊपर एक नहीं, और हाँ ये. So there are few landmark cases of the Honorable Supreme Court, as well as why bail should be granted to someone. That bail is granted when the investigation is completed. Bail is granted when no fruitful purpose will be served by keeping an accused behind bars. So what is a fruitful purpose? First is investigation is to be done from the accused. When an investigation is completed, you can state in your argument that investigation of the crime is completed. There has been recovery from the accused, or there is no recovery to be made, new recovery to be made from the accused, then you can state that there is no new recovery to be made from the accused. So what is the purpose of keeping the accused behind bars? If an accused, his livelihood will be affected while he is kept behind bars, then you can state it before the court that his livelihood will be affected. If there are any medical conditions that the accused is undergoing, so if he has heart related conditions or any other sickness, illness which cannot be treated while he is under custody, you can take that also as a part of your arguments of a bail application. Then if any of his family members, either his mother, father, they are undergoing any treatment or any illness, and it is important that this accused is with should be out of jail to take their care. This is also something that you can stress out, and courts do grant bail on such grounds also. Then if his has his family who are dependents on him, like if an accused is married and he has his wife and children whom he have to survive, and then if he stays behind bars, then he won't be able to take care of them, or he won't be able to provide for his family. And if that gravity of offense is not that serious, then court can consider granting him bail on these grounds also. Or his parents who are dependent on him. So there are various aspects on which court grants bail. So there is one more aspect to a regular bail, that a regular bail can be filed before charge sheet and after charge sheet. So if an bail is, you file a bail application after charge sheet, then you can focus on this aspect that change in circumstances, investigation is completed. Now there are few cases of the Honorable Supreme Court wherein they say that filing of charge sheet is not a change in circumstance, but you can argue, when such an argument is put before you, that filing of charge sheet by the public prosecutor, generally these questions come up from the public prosecutor side only, that change in filing of charge sheet is not a change in circumstance. So while such arguments come before you, you can state that this filing of charge sheet means that investigation is completed. If investigation is completed, the statements of the complainant are recorded, they are before the court, then all of the necessary evidence is before the court. And in such circumstance, the major what we can say is the major doubt that is there in the mind of the court, that if accused is released on bail, he can tamper the evidence or he can pressurize the witnesses. Then when investigation is completed and charge sheet is filed, there is no reason to have for the court to have the doubt that the accused may tamper with the evidence, or that he may pressurize the statements of the witnesses. And such, all of these arguments you can form if an theory is brought before you while you argue a bail application, that change in filing of charge sheet is not a change in circumstance. Also, while you argue or draft a bail application, always keep in mind, if the offense pertains to victim who is a girl child or a child of under the POCSO Act, or any offense that relates to a woman or offense against women, you should always keep in mind that you should not disclose the identity of the victim or the complainant, either in your draft or by way of when you are arguing the bail application. It is very essential, because Satendra sir, if you can go down to section 72 and section 23 slide. Victim identity protection. It is very important while you argue and draft a bail application that you protect the identity of the victim. Recently, Bombay High Court, the bench of Revti Moite Dere madam, has fined an advocate for ₹25,000 because he disclosed the identity of the victim in his bail applications that was circulated to the registry. So this is very important that you hide the identity. So most of the times what happens is, during arguing a case of POXO or a offense against women, wherein you are trying to show a consensual relationship, you try to bring out the WhatsApp chats and the photos and videos of the accused and victim. So what happens is, if you do not mask the identity of the victim or the complainant while you put these photographs or chats before the court, then you can be penalized or under section 72 of the Bhartiya Nagarik Suraksha Sanhita. Or as this judgment of this Bombay High Court has came, there must be or these judgments of other courts also relating to this. But then section 72 has a it is an offense under section 72 of Bhartiya Nagarik Nyaya Sanhita, that you disclose the identity if you disclose that. So keep in mind, while arguing a bail application, strict and drafting a bail application, do not reveal the identity of the victim in any manner. So, sir, if you can come to the do's of arguing a bail application, slide where Satyendra sir, upar. Be brief, be concise. While you argue, first thing you keep in mind, don't make it lengthy. Don't try to conduct a trial at the stage of bail. Try to focus on why bail is necessary, why your accused deserves to be released on bail. Then there are police papers that are not shown to the advocates of the accused, mostly, that are for the purpose of the judge only, and the court and the public prosecutor tenders it to the court if the court or the investigating officer, if the trial court asks the investigating officer or the public prosecutor, they produce it for the perusal of the court. But in case if there are some senior advocates, they already, if they are well established, and they can directly ask the court for police papers, and they can check if the victim has undergone or the complainant has, in cases of offenses where injury is suffered, they can check the papers from the court, they can ask for. But generally, for junior advocates, it is a little difficult to ask the judge for the police papers and investigation papers. Mostly the junior advocates are denied as on the pretext that investigation is undergoing. So you feel a need that you should see the police papers which are brought before the court by the public prosecutor or the investigating officer while your bail application hearing is pending. Then you can politely ask the court that I'll like to see with the permission of the court, I'll like to see the police papers, and if the court is generous enough, the judge will show those papers to you, and then you can find out your lacunas or contradictions from those papers. Then stress, if there is delay, point the delay out. Use judgments that support your facts, that support people. What happen is, people bring many advocates try and bring judgments from various high courts and then Supreme Courts, and the judge gets irritated. Trial courts का judge का जो ego है, you have to क्या उसका मतलब, you have to worship their ego. You have to keep in mind that while you argue your bail application, and this is I am specifically telling for junior advocates, क्योंकि for senior advocates कैसे, they guys have settled in their life, they have a clientele that keeps coming back to them. But while we are in a junior stage, what happens is, if you guys go aggressively before a court, and if whatever the order of any order or judgment, it is in the hands of the court, it is in the hands of the judge. If you want to be gentle, if you want to be polite, and if that judge rules against you, then ultimately you will be the sufferer. Your client is going to be a sufferer. But ultimately, you as a new litigation practitioner, you will suffer, because there is scarcity of clients. And in the essay situation, if you lose a client because of your approach towards the court, it is not good. So try to be gentle, polite. And I have seen that if you are gentle and polite, you yield results. तुम्हारा केस भी, if your case is also not strong, then then also few judges will consider you कि एक sympathy, you will get a sympathy of being a junior advocate, or you can win over the court or the judge who is presiding the court by your politeness. And then you get few, not all the time this happens, but at times the judge likes your politeness, likes your kind, gentle attitude towards the court, and he may rule in your favor. So keep these things in your mind. And earlier I've mentioned that the victim identity should be protected while you argue a bail application. So these are few things that you should be doing while arguing a bail application. So if you can go to the next part. Next slide. Don'ts. So as I've already stated, do not conduct a trial at the stage of bail. Try and be concise. Try and focus on prima facie, how the case is not made against you. Try and stress on the fact that why it is important that your accused should be laid out on bail. What all dependencies are there on him, how his family, he himself will be affected, he is kept behind bars, and then focus on all those aspects that investigation is completed, everything. Do not, as I already told you, do not overstate facts. State the facts that support your case only. Do not state, or even if you state the facts that are serious allegations against you, try and finish them up in such a manner that the judge does not keep dwelling upon those facts. So you should state it in a faster manner, or just you should hide them somewhere in your while stating in a style that the judge does not get time to focus on those facts, because ultimately the public prosecutor is going to go to that serious allegations. But it is your duty to suppress it as much as possible. Suppress, not in a sense that suppress the facts from the court. Do tell the court, but don't let the court's attention go on those serious facts. And very important thing is, whenever a judge stops you in middle of any argument, stop at that. If the court interrupts you, stop arguing, look at the court, be calm, and listen to whatever the judge says. Try and answer any, what we can say, any query that the judge puts before you. What happens is, most of the time we are in the flow of our arguments, and then what we do is we don't want to be interrupted, and then we get irritated if the judge puts a question before us, and instead of trying to satisfy the court, we are in a hurry to move further off with our arguments, and then we do not satisfy the court in that haste. And so what happens is, the court gets a different it creates a different impact on the mind of the court. If it is time consuming, even if you are not willing to answer to the court, or even if you do not have an answer to the court, try and listen to the judge. If he interrupts you during an argument, try and satisfy his query. And it is very important that I've seen most of the advocates, what they do is, they do not, most of the times advocates don't understand only what the judge is trying to say, or sometimes the queries of the judge are so vague that you are also unable to interpret what the judge is, as an advocate, what the judge is trying to say. But try and listen to them, and if you do not have an answer, politely say that, sir, I do not have an answer to this, and I'll read it and I'll come back to you. So try all of these tactics. While you are submitting chats, WhatsApp chats, you are submitting photos, try and see that you do not submit fake chats or fake photos, because ultimately even our clients, they are going to provide us with material. They are very anxious, and then relatives of the clients are anxious that we have chats and we have photographs and we have videos, and go and put it before the judge and we have a good case. It is advocate's sole duty to look into the fact that what should be put before a judge. Sometimes what happens is the clients bring documents and then it backfires, or videos, then it backfires. Recently, I was arguing a bail application and an opposite party brought an I was for the victim, and the opposite party were representing the accused. They brought a video of the accused family. They were talking with the victim over phone, and then that backfired to them, because ultimately I, as an advocate of the victim, stated that they are trying to pressurize the victim, and then the bail application was rejected. So court ke samne, what you have to put before the court, as an advocate, it is your own duty, and you should use your own intellect. You should not come under the pressure of this relatives of the family, with the accused or his family members, or the accused himself, and put everything that they hand over to you before the court while arguing a bail application. This same goes for trial also. But because that we will be covering in the future, but because we are talking about bail applications, and now this is a fashion and trend that we put the accused lawyers of the accused applicants, they nowadays put everything material that they get before the court to show that prima facie case is not made against their client. So these are few things you can note this down from the slides that I've created. And try and respect. If it is a crime against women or crime against a crime under POCSO, try and respect the allegation, seriousness of allegations. Don't be casual while dealing with these allegations. Though we are representing an accused, it should not look like we are not taking these allegations seriously, or we are in some way not respecting these allegations, and that some judges find that also, and that they have rejected bail applications to this also. What happened recently was same chats were produced and photographs were produced, and in the bail order the judge wrote that these chats and consensual relationship material, whatever these arguments are in directly a character assassination of this victim, and then the judge rejected that bail application of the advocate. So you guys should keep all these points in your consideration while you argue a bail application. Sir, if we can move to the next slide. Next. So one of the very important aspect is that that has been come into picture because of the judgment of this Arnesh Kumar versus State of BR, and then it was followed also in the judgment of Satyendra Kumar Antil versus CBI. I'd like you guys to note down these two judgments. These are landmark judgments which are nowadays widely used in the trial courts while deciding a bail application. So what happened in the judgment of Arnesh Kumar? I'll just briefly state it, and you guys can go and read the judgments from internet. You will easily find both of these judgments. Satyendra Kumar until still there are guidelines were issued in 2026, January month of 2026 again, regarding the written grounds of arrest in the case of Satyendra Kumar until. So what happened basically in the judgment, what is the after effect of judgment of Arnesh Kumar is that section 41A, which was a section in criminal procedure code, and now it is replaced by Bhartiya Nagarik Suraksha Sanhita section 35, wherein offenses, the Supreme Court has stated that, and this is now a practice, at least in Maharashtra and district courts in Maharashtra, this is a practice that wherever an offense with punishment of 7 years is committed, maximum punishment of 7 years, then the police do not arrest the accused because of the guidelines issued in the case of Satyendra Kumar and this Arnesh Kumar versus State of BR. And what has happened is these guidelines state that whenever arrest is not necessary, the investigating officer can give a notice to this accused, and then accused should cooperate with the investigating machineries. And if he cooperates with the investigating machineries, then his arrest is not required. And so it is now widely a practice in Maharashtra, at least, that for offenses with maximum punishment of 7 years, the police do not arrest the accused. And so they are issued a notice under section 35 of the Bhartiya Nagarik Suraksha Sanhita, and then after the charge sheet is filed, a summons or a notice is given to the accused, and then the accused appears before from the court itself. A summons or notice is issued, and then the accused appears directly before the court, and then he files his bail bonds, and then he is released on bails. So both of these judgments are very important and crucial, and I'll tell you guys, I want you guys to write them down and go through them and read them in detail, and you will get much more about what has been laid down as per section, as to section 41A's compliance and about arrest. So if there are other landmark judgments also regarding specifically regarding anticipatory bail, on the next slide, Satyendra sir. No, next after this. So anticipatory bail, ऊपर वाला. Anticipatory landmark judgment. So the first landmark judgment regarding to anticipatory bail was Gurpak Singh Sibba versus State of Punjab. I have written given the citation also of these judgments. You guys can get them from the internet. You can note these judgments down, and you should read these judgments. If you are a practicing advocate, it is very important that you go through Arnesh Kumar, Satyendra Kumar until Gurpak Singh Sibba versus State of Punjab. Then those guidelines were again. Then this Gurpak Singh was again referred to in the case of Siddharam Maitre versus State of Maharashtra in 2011. And then came the case of Sushila Agrawal versus State NCT of New Delhi, which was in 2017, and these all lay down the guidelines relating to anticipatory bail. So what has happened in Bhartiya Nagarik Suraksha Sanhita? There is a contradictory approach that has been taken up in Bhartiya Nagarik Suraksha Sanhita regarding to offenses under section 64 subsection 2, 66 and 70. By section 483(4) subsection 4 of the Bhartiya Nagarik Suraksha Sanhita says anticipatory bail provisions are not applicable to any offense under section 64, section 2, section 66 and section 70 of Bhartiya Nyaya Sanhita. And so in this case of Siddharam Maitre and Sushila Agrawal, the Honorable Supreme Court has held that the application of anticipatory bail is wide, and it is applicable even to heinous offenses or grave offenses also. Now, this provision of Bhartiya Nagarik Suraksha Sanhita is directly in contradiction with the judgment of Sushila Agrawal. And so I'd like you guys to go through the judgment of Sushila Agrawal's, then judgment of Siddharam Maitre. Also read section 483, section 4 of Bhartiya Nagarik Suraksha Sanhita, and you can yourself point out the difference that and contradiction that is there in the law, whatever the guidelines have been issued by the Supreme Court or what is held by the Supreme Court in these judgments, and section 483 of the Bhartiya Nagarik Suraksha Sanhita. And now coming to the closing part of arguing a bail application. While you close your bail application, state your prayer. While stating your prayer, state that the accused may considering all about the grounds that have been stated before the court may kindly release the accused either on regular bail or anticipatory bail, and then conclude. Then for what happens is, while arguing a bail application, as an applicant or accused, you are the first to argue the bail application. So after you, the prosecution or the public prosecutor is going to argue. And if there is the victim is issued a notice in a bail application, then the lawyer of the victim or the complainant, whatever the case may be, they will argue after the public prosecutor argues. So then you have to obviously rebuke the submissions, whatever made by the public prosecutors. Try and keep those rebuttals short. Try and focus on important aspects only, whichever the public prosecutor brings before the court. And try and not strengthen your rebuttals into a large argument so that the court gets, because already the court is tired by firstly hearing you, then the public prosecutor, then hearing the victim or complainant's lawyer, and then you get up before you rebut, try and ask for permission of the court. Whatever you do before a trial court, or I'm not talking about high courts, but before a trial court, there is time, there is ample time. Try and seek permission of the trial court while you do anything. While you want to rebut also to the arguments advanced by this public prosecutor, try and get up, ask permission of the court, and if the court is willing and ready, then in brief and short, rebut the submissions made by the public prosecutor. So this is all that you should keep in mind. While I have tried to cover most of the things that I have in my mind while telling you guys about the do's and don'ts of arguing a bail application. Now I'd like to, sir, Satyendra sir, if we guys have, first of all, please note down all these cases that I've brought, that are displayed on the screen, so it will be easy for you. And Satyendra sir, if we are going to take questions, let me know.
Sure, sir. Participants, if you have any questions, you can unmute
Please
yourself
ask
and
one
ask.
by one.
Yes, please ask one by one.
Sir, good evening. Anupam here. Sir, I'm a first year law student and it was a great and helpful session. Thank you so much, sir.
Yes.
Hello.
Yes, welcome.
Yes, sir. Yeah, sir, one more thing I want to just understand. So, is there any, sir, book or any specific material that I should read just to get in the habit of knowing the bail procedures
So
and how to write it down?
initially, as a first year law student, you should focus on the this bare acts you have of Bhartiya Nagarik Suraksha Sanhita or Bhartiya Nyaya Sanhita. So bail provisions are enshrined from section 478 to 483, 485. You can read those sections, and if you are in a college or you have a library access, then get a good commentary, and from that commentary also you can read more about these sections wherein there are many case laws. Now what has happened is, as these laws have changed, you won't get a fresh commentary, but old commentaries will also work. You can with the corresponding sections of CRPC, you can read them, and commentaries available about them, and then it is better that you read commentaries as of now. And this
So,
section,
any specific author's commentary I should read, or
specific, right now I'm not having a single name in my mind, but I will, if you can forward your query to Satyendra sir, I'll text you all those names.
okay?
Sir, one more
I
question.
will definitely do that. Just forward your query. I'll give you names of 4 to 5 authors. Those you can read.
Good evening,
But
sir.
sir, how
Welcome from Hyderabad.
to how should I forward the query?
So you can take Satyendra's number, na? Satyendra sir's number is here, na? You guys must be having.
Sir, good
Satyendra
evening,
sir, can you please put your number in the chat box?
Yes, sir. I am putting the number in the
Yes,
chat.
yes.
Good
Yes,
afternoon,
Shrikant.
sir.
Good
I'm
evening,
Samiksha
here.
from
I'm
New
from
Delhi.
Hyderabad. So basically, my question here is: see, normally in the bail, it is they just judges are preconceived. They don't even hear complete argument, and we cannot go beyond certain things. We basically focus only on 1 or 2 points, and if we say that you can speak those things in trial, but even if we are having a strong foundation, we are not allowed to speak all those things. So how to overcome those things?
So Shrikant, I understand your query, and I know what happens before trial judges. They are very reluctant at times. Many of the trial judges are very reluctant to hear your arguments, and they're like, finish it up in 5 minutes, sum it up fastly. So at that time, so what is your basic thing is focus that prima facie this case does not stand against your accused. First, focus on your defense. As I have told you, Shrikant, that defense is very important. While you argue a bail application, try to form a defense and focus on it, and then why your client and his liberty should be protected. Focus on this aspect only. So whatever you do, Shrikant, what will happen is ultimately the order it is in the hands of the judge only. However hard you try to put up your case, or this is going to happen that some judges won't listen to you. Try your arguments, try and focus that. Can others please switch off their mics? So she can try and focus on your defense, and then why liberty of your client should be protected. Ultimately, argue these things in short. While even if the judge is reluctant, then you also have to be a little persuasive, and just you have to be a little, what we can say is, you have to push a little.
Yeah, I agree. I'll just give an example, small example happened recently. So there was a road side argument sort of thing. A taxi driver had a altercation with a local students, let us say around 20-year students. They were drunk. It is at 11:30, just exactly opposite the railway station. So during that quarrel, they beat that taxi driver and they have taken his mobile phone. Now it is booked under dacoity case now.
Yes.
They are all from that nearby station only. So all were taken into custody. And since it is dacoity case and more than 5 people are involved, judge was, I told, sir, how can they do dacoity and just grabbing a mobile phone if you take so serious section and they are students? Let them be in jail for 10 days. What will happen? Let them be. This is the attitude. So I was surprised.
This attitude is there.
He know very well that it is case will not stand. And he know very well, he just, yeah.
No, some judges have this attitude. Recently, what happened a day before yesterday only, last Friday, last Friday, a judge rejected a bail application of mine. I had a very strong case on consensual relationships. I had even given a very good Supreme Court's case about Romeo-Juliet clause to be included in the POCSO Act. I had given checks and everything. And the judge rejected my bail application, stating that for the time being, as investigation is pending, I have rejected the bail application. So, as you say that the still rehne do unko jail mein, these are that you cannot predict what the mind of judge will work and what reason they will cite while deciding a bail application.
No, he simply told me, let them be so that they will not repeat in future. They are students, it is a lesson for them.
So that is a human aspect of being a judge.
So of course, he gave me in second application. That is different.
Yes. Any next question?
Good evening, sir. There is a very small, I want to just ask a question.
Yes.
Can we get recorded and that PDF of which you mentioned?
Yes, I will ask Satyendra sir to forward it to you.
You all get it after the class.
Sir, your voice is not coming properly. Can you please speak again?
The recordings will be provided in the WhatsApp groups. No worries about.
And the PDF also?
Yes.
Thank you so much.
Sir, my question is that is there any bail available in the civil suits or in NI Act also?
Yes, in NI Act is a quasi-civil kind of a proceeding, and in NI Act it is you have to give bail because it falls under criminal proceedings. At least in Maharashtra and very many states also, I've also seen in Gujarat also, it falls under criminal law only, and criminal law is only applicable to it. But then its nature is a little bit in question. But for time being, it falls under criminal law only. And then first, when the accused appears before the court at the initial stage, he has to give bail. And in civil, it is civil prison, and it is mostly happens in execution proceedings. But it is a different aspect. That is not. It is not. So bail and the civil prison are totally two. Detention under criminal law and detention under civil law are totally two different concepts. But NI Act, yes, you have to furnish bail for the accused whenever he appears before the court, and he has to file surety as well as bail bonds for his appearance.
If the court award the in the NI Act, the court award the accused to the jail. So is there any sudden bail available?
Yes. Bail is a right in NI Act also. And mostly 90%, 95% of the times courts don't take the accused in custody. Only when do the courts in NI Act proceeding, when the judges take the accused in custody, if he has jumped his bail, if he has or he has not, even after issuing him a warrant or a non-bailable warrant, or he he has multiple times cancelled the non-bailable warrants, or there is a proclamation that has came to be issued against the accused. In such cases only, then what happens is court keeps the accused in custody, but it is for minimum time. It is minimal time. They don't do it for over that till the completion of trial or something. Just it is a practice to bring fear in the mind of the accused, and he should not repeat the mistake again. For that purpose, judges keep the accused in custody, but it is very negligible. And once an accused is produced before the court, he has the right to give bail in NI Act.
Sir, in NI Act, if we go to appeal in Sessions Court, and Sessions Court also award the punishment, then we cannot get a dispensation from, we cannot go for appeal immediately, so they will arrest. So how we have to deal in
you have to file a application for bail, because the punishment prescribed is under 2 years. It will be granted, and you will be granted an appeal period of around 30 days or 60 days, depending on the view of the court. And till that period, you are you are released on bail, and then in the meanwhile you have to appeals. You have to go before the appeals court, appeal, and get an order of cancellation of sentence as well as grant of bail from the Court of Appeals.
Yeah, so but in Sessions Court they are not allowing us that 30 days time in Session Court judgments.
So what happens, Shrikant sir, it depends from judge to judge or the court to court, procedure to procedure. Here in Maharashtra, they do give us time frame to go in appeal.
No, if it is the Session Court is on appeal, I'm not saying that it's a direct Session Court case. If it is the first case, it is okay. I lost the case in Magistrate Court, then I appealed in Sessions Court. I lost the appeal, then I am convicted in Session Court. Then they are not giving the time.
They are not giving you time.
Yes, if it is the direct Session Court time, they are giving the time.
The session NI Act's appeal firstly goes to Sessions Court only.
No, yeah, appeal goes to Sessions Court.
Sessions
so
Court
I lost there also.
And then it goes to High Court. But
yes, so but I lost in Session Court.
But generally, here in Maharashtra, the procedure is, if the punishment is below 2 years, they will release you on bail and they'll give you an appeal period. So,
if the Session Court is not applied for the appeal, so we can go for the High Court or
High Court. If Session Court rules against you, then High Court. Suddenly you can go. Right now we are talking about bail. If you can focus on bail.
Secondly, you cannot go in an appeal. So until appeal is dismissed, you cannot go to High Court. You cannot have two cases simultaneously in different courts.
That only has said after it is ruled against you. But right now we are focusing on bail. If there are questions about bail, I'd like to address them of any other participants. Appeals will be dealt by in the seminar by advocate of High Court, the Supreme Court. She's an AOR and she will be dealing with the appeals part. So it is better that we keep those questions for the other session and we concentrate on bail as well.
Sir, could you conclude?
Yes, we can. Chalo. Thank you guys for being here.
Thank you so much, sir, for this insightful session. And thank you every participant for being throughout the session. Thank you everyone.